They slid the document across the conference table at 9:43 on a Tuesday morning. Intellectual property assignment agreement. My side projects, the ones I built on my own laptop at home on weekends, now belong to them. I read it twice, looked up at my manager and the HR director, and said the 5 words that would change everything. "See you in court." The HR director blinked. My manager, David, leaned back in his chair like I had just told him the sky was green. "We don't want it to come to that, Ella. This is standard practice. You used company knowledge to build those applications. I used Stack Overflow and my own brain. On my own time. With my own equipment." The conference room smelled like stale coffee and the faint chemical scent of the whiteboard markers someone had left uncapped. Through the glass wall, I could see the rest of the engineering team at their desks, headphones on, unaware that the company was trying to claim ownership of 2 years of my nights and weekends. The fluorescent lights hummed overhead, that constant buzz that you stop hearing until you are sitting in a room where the only other sound is your own heartbeat. David pushed his glasses up. "You signed an employment agreement. All inventions conceived during your employment belong to the company." I pulled out my phone, opened my notes app, and read the actual clause. "All inventions conceived during employment using company resources or relating to the company's business." My projects do not relate to your business. You build project management software for construction companies. I built a meal planning app and a personal finance tracker. And I did not use a single line of company code or a single minute of company time. The HR director, whose name was Patricia and who had been with the company for 6 months, folded her hands on the table. "We have consulted with legal counsel. The language is clear. Then your legal counsel should prepare for litigation. Because I consulted with mine too, and the language is very clear. In my favor." That was not entirely true. I had not consulted with a lawyer yet, but I had read the employment agreement 17 times over the past 3 days, ever since David had pulled me aside after stand-up and asked about the apps I had mentioned in a casual conversation. I had read California Labor Code Section 7830. I had read every case I could find about employment IP agreements. And I knew, with the same certainty I had when I debugged code, that they did not have a case. Patricia's expression did not change. She had that HR face, the one that is professionally sympathetic and completely unmovable at the same time. "We would prefer to resolve this amicably. If you refuse to sign, we will have to consider whether your continued employment is compatible with company interests. So you are threatening to fire me if I do not hand over my personal projects. We are saying that we need team members who are aligned with company policy." I stood up. The chair scraped against the floor, too loud in the quiet room. "I am aligned with the law. You will be hearing from my attorney." I walked out of the conference room, past the glass walls, past the desks with the standing desk converters, and the mechanical keyboards and the monitors displaying lines of code. My hands were shaking, not from fear, from anger. The kind of anger that starts in your chest and spreads out until your fingers tingle and your vision sharpens and every detail becomes hyper-real. The sound of the Slack notification pings. The smell of someone's microwaved lunch. The texture of my laptop bag strap digging into my shoulder as I grabbed it from my desk. I did not go back to my desk. I walked straight to the elevator, rode down 12 floors, and stepped out into the San Francisco fog. It was late November, and the cold wrapped around me like a blanket. I could breathe again. My phone buzzed before I reached my car. An email from Patricia. Subject line, follow-up to our meeting. I did not open it. I knew what it would say. Some version of, "We are disappointed in your response. Please reconsider. We value you as an employee." The same script every company uses when they are trying to take something that does not belong to them. I sat in my car in the parking garage and opened my laptop. Not the company laptop. My personal MacBook, the one I had bought with my own money 3 years ago. I opened the terminal and ran git log on my meal planning app repository. 463 commits, every single one time-stamped, every single one made between 8 p.m. and midnight or on weekends. Every single one from my home IP address, which I could prove with my router logs if I needed to. Then I opened the finance tracker repository. 312 commits. Same pattern, same timestamps, same IP address. I had the evidence. I had the law on my side. What I did not have was a lawyer. I pulled up my phone and started searching. Employment lawyer, San Francisco. IP attorney, California. I needed someone who understood tech, who understood employment law, who would not back down when a company with venture capital funding tried to bury us in paperwork. The first 3 firms I called had consultations booked out for 2 weeks. The 4th firm, a small practice in the financial district, had an opening the next morning. I took it. That night, I could not sleep. I lay in bed staring at the ceiling, running through every conversation I had ever had with David about my side projects. I had been careful. I had never worked on them at the office. I had never used company resources. I had never even connected to the company VPN when I was coding at home. But I kept thinking about Patricia's face, that absolute certainty that they were right and I was wrong. And I kept thinking about the other engineers on my team. How many of them had side projects? How many of them had been told the same thing, that their nights and weekends belonged to the company, and had just signed the paper because fighting seemed too hard? I got out of bed at 2 a.m. and made a list. Every piece of evidence I had, every document I would need, every argument they might make, and every response I had prepared. I was a software engineer. I solved problems by breaking them down into smaller problems and tackling them one at a time. This was just another problem. And I was very good at solving problems. By the time the sun came up, I had a plan. And I had something else too. A sense of absolute clarity. They had made a mistake when they tried to take what was mine. Because I was not going to roll over. I was not going to let them bully me into signing away 2 years of my life. I was going to fight. And I was going to win. If you want to see how this legal battle unfolds, hit that like button and subscribe. Because what happened next was just the beginning of their end. The meal planning app started because I was tired of throwing away groceries. That was it. No grand vision, no startup dreams. Just me, standing in front of my refrigerator on a Sunday night, looking at wilted spinach and expired yogurt, thinking there has to be a better way. I built the first version in 3 weeks, a simple interface where you could input recipes and it would generate a shopping list organized by store section. Then I added meal scheduling. Then I added nutritional tracking. Then I added the ability to share meal plans with roommates or family. Every feature came from a real problem I was trying to solve. By the time I was done, it was actually good. Clean code, intuitive design, fast performance. I showed it to my roommate, and she asked if she could use it. Then she showed it to her sister. Then her sister showed it to her book club. Within 2 months, I had 300 users I had never met. The finance tracker came next. I had been using a spreadsheet to track my spending, but spreadsheets are not built for pattern recognition. I wanted something that could tell me I spent 40% more on coffee in months when I was stressed, or that my grocery bills spiked every time I skipped meal planning. I wanted insights, not just data, so I built it. Another 3 weeks of nights and weekends. Another app that started as a personal tool and turned into something other people wanted to use. I never monetized either of them. They were just out there, free, helping people. I had a full-time job. I did not need the apps to make money. I needed them to keep my brain engaged, to remind myself that I could still build things that mattered, even if my day job was mostly fixing bugs in legacy code. The company I worked for, Apex Solutions, built project management software for construction companies. Gantt charts, resource allocation, budget tracking. Solid product, boring work. I had been there for 3 years. I was a senior engineer, which meant I got to review pull requests and sit in more meetings. But the actual coding was mostly maintenance. We were not innovating. We were not pushing boundaries. We were keeping the lights on for clients who paid their invoices on time. I did not hate it. It paid well. The benefits were good. My coworkers were fine. David, my manager, was the kind of guy who said things like, "Let's circle back and touch base offline," but he left me alone to do my work, which was all I really wanted. The office was in Soma, one of those converted warehouse spaces with exposed brick and too many conference rooms named after famous inventors. We had a kitchen with a fancy espresso machine that was always broken, and a lounge area with beanbag chairs that no one ever sat in because they were impossible to get out of gracefully. The engineering team was 23 people, mostly men, mostly in their 20s and 30s, mostly wearing the same Patagonia vests and Allbirds shoes. I kept my side projects quiet at first. Not because I thought I was doing anything wrong, but because I did not want the attention. I did not want people asking when I was going to quit and do my own startup. I did not want the pressure of turning something I loved into something that had to make money. But then, 3 months ago, I made a mistake. We were at a team lunch, one of those forced bonding things where they order too many pizzas and everyone stands around making small talk. Someone asked what we did outside of work. Most people said hiking or climbing or cycling, the standard Bay Area answers. When it was my turn, I mentioned that I had built a couple of apps. David perked up. "What kind of apps?" "Just personal projects. Meal planning, finance tracking." "Are they on the App Store?" "No, just web apps. I host them on my own server." He nodded, smiled, and the conversation moved on. I thought that was the end of it. 2 weeks later, he pulled me aside after stand-up. "Can we chat for a minute?" We went to one of the small conference rooms, the one with the broken blinds that let in too much afternoon sun. He closed the door, which was unusual. David was a big believer in open communication, which mostly meant he never closed doors. "I wanted to follow up on those apps you mentioned, the meal planning one and the finance tracker." "Okay, have you thought about bringing them in-house?" "We have been talking about expanding our product line. Personal productivity tools could be a good fit. I do not think they are a good fit for Apex. Your clients are construction companies. These are consumer apps." "Right, but the underlying technology, the data architecture, that could translate. I appreciate the interest, but I am not looking to sell them or partner on them. They are just hobby projects." He leaned back in his chair, and something in his expression shifted. Just slightly, but I noticed. I had been debugging code long enough to recognize when someone was about to tell me something I did not want to hear. "I understand, but I do need to ask. You built these while you were employed here, right? On my own time, with my own equipment?" "Sure, but you are using skills and knowledge you developed here. And our employment agreement covers inventions created during your employment." My stomach dropped. Not a lot, just enough to know that this conversation was not going the direction I had assumed. "The agreement covers inventions related to the company's business. These are not related. That is a legal interpretation. I am not a lawyer. But HR wanted me to flag it." "Flag what exactly?" "That we might have a claim to the IP. I am not saying we do. I am just saying it is worth looking into." I kept my face neutral. "Okay, let me know what you find out." I left that meeting and went straight to my desk. I pulled up the employment agreement I had signed 3 years ago. I read the IP clause. Then I read it again. Then I spent the next 2 hours reading California labor code and case law. The law was clear. Employers could not claim ownership of inventions that did not relate to their business and were not created using company resources. My apps did not relate to construction project management. I had not used company code, company time, or company equipment. I had a case, a strong one, but I also knew how these things worked. Companies did not care about the law. They cared about leverage, and they had more money, more lawyers, and more time than I did. I should have started looking for a lawyer right then. But I did not. I told myself I was overreacting. David had just been asking questions. HR was just doing their due diligence. Nothing was going to come of it. I was wrong. 3 weeks later, Patricia from HR sent me a calendar invite. Meeting to discuss employment agreement. I knew before I even walked into that conference room what they were going to say. And I was right. The law office was on the 14th floor of a building in the financial district. Small reception area, 2 chairs, a desk with a receptionist who looked like she had seen every kind of legal crisis and was not impressed by any of them. I gave her my name and sat down to wait. The lawyer's name was Jennifer Kwan. I had found her through a legal directory that specialized in employment and IP law. Her website said she had worked at a big firm for 8 years before starting her own practice. She had handled cases against tech companies. She did not lose often. She came out to get me herself. Mid-40s, black suit, hair pulled back in a bun that looked like it had been the same style for 20 years. She shook my hand with the grip of someone who spent a lot of time in depositions. Her office was small but organized. Bookshelves lined with legal texts, a desk with 2 monitors, a window that looked out at another building. She gestured to the chair across from her desk. "Tell me what happened." I told her. The whole story, from the team lunch to the HR meeting to walking out. She took notes on a legal pad, the old-fashioned kind, and did not interrupt once. When I finished, she set down her pen. "Do you have the employment agreement?" I pulled it up on my phone and handed it to her. She read it, scrolling slowly, and I watched her face for any sign of what she was thinking. Nothing. Lawyer face was even better than HR face. "Do you have evidence that you built these apps on your own time and equipment?" "Yes. Git commit logs with timestamps, receipts for my personal laptop and server hosting. Router logs showing my home IP address. I can prove every single commit was made outside of work hours and outside of company infrastructure. Do the apps relate to the company's business in any way? No. They build project management software for construction. I built a meal planning app and a finance tracker. Completely different markets, completely different technology stacks. Did you use any company code, libraries, or resources? Not a single line. I can show you the repositories. Everything is original or open source." She leaned back in her chair. "They do not have a case. That is what I thought. But they are going to try anyway. Companies like this, they think they can bully employees into signing over their rights because most people cannot afford to fight. They will drag it out, make it expensive, make it exhausting. They are betting you will give up. I am not going to give up." She looked at me for a long moment. "Good. Because this is going to cost you. Time, money, stress. Even if we win, and I think we will, it is going to be hard. How much are we talking?" She quoted me a retainer fee that made my stomach clench. Then she explained the hourly rate, the estimated timeline, the potential costs if it went to trial. I did the math in my head. I had savings. Not a lot, but enough to cover the retainer and a few months of legal fees. If it went longer than that, I would have to figure something out. "I will do it." She nodded. "Then let us get started." The first step was gathering evidence. Jennifer gave me a list of everything she needed. Employment agreement, offer letter, any company policies related to IP, all communication with David and Patricia, the Git logs, the receipts, the router logs, anything that could prove when and where I had built the apps. I spent the next 3 days compiling it all. I exported every email. I pulled every commit log. I dug through my file cabinet for the receipt from when I bought my laptop. I logged into my router admin panel and exported 3 years of connection logs. The Git logs were the strongest evidence. Every commit had a timestamp and an IP address. I could show, line by line, that I had built these apps between 8 p.m. and midnight on weekdays and during the day on weekends. I could show that every single commit came from my home IP address, never from the company network. I also pulled my work laptop logs. I had never connected my personal repositories to my work laptop. I had never even opened the code on my work machine. The separation was complete. Jennifer reviewed everything and sent me a message. "This is excellent. They are going to have a very hard time arguing you used company resources." The next step was responding to their cease and desist letter. It arrived 4 days after I walked out of the HR meeting. Formal legal letterhead, 3 pages of dense text, demanding that I immediately cease all development and distribution of the apps and assign all rights to Apex Solutions. Jennifer drafted a response. It was polite, professional, and absolutely uncompromising. She laid out the law, cited the relevant cases, and made it clear that we had no intention of complying with their demands. She ended with an invitation to discuss the matter further, which was lawyer speak for "bring it on." Their response came 2 weeks later. They were filing a lawsuit. I was at home when Jennifer called to tell me. I had been expecting it, but hearing the words still felt like a punch. We are being sued. It made it real in a way that the HR meeting and the cease and desist letter had not. What happens now? Now we respond. We file an answer to their complaint. We start discovery. We build our case. How long will this take? Months? Maybe a year? Maybe longer. I sat down on my couch. My laptop was open on the coffee table, the meal planning app running in a browser tab. 300 users had turned into 800. People were using it every day. They were sending me thank you messages, telling me it had changed how they thought about food and waste and planning. And now, I was being sued for building it. Okay, let us do it. The lawsuit was filed in San Francisco County Superior Court. I read the complaint 3 times. It was full of legal language that made my work sound sinister. Defendant willfully misappropriated company resources. Defendant breached her fiduciary duty. Defendant engaged in unfair competition. None of it was true. But truth was not the point. The point was to make me look bad, to make a judge think twice, to create enough doubt that they could win. Jennifer filed our answer 2 weeks later. It was twice as long as their complaint and 10 times more detailed. She did not just deny their claims. She dismantled them. She cited the employment agreement language. She cited California Labor Code. She cited case after case where courts had ruled in favor of employees in situations exactly like mine. And then she did something I did not expect. She filed a cross-complaint for declaratory relief, asking the court to declare that I owned the apps, and for violation of California Labor Code because their employment agreement language was overly broad and unenforceable. We were not just defending, we were attacking. I asked her why. She said, "Because they need to know you are not going to roll over. They need to know this is going to cost them too." Discovery started in January. That meant both sides had to turn over documents, emails, policies, contracts, anything relevant to the case. I turned over everything I had already given Jennifer. They turned over my personnel file, the company IP policy, and a stack of emails between David and Patricia about my apps. Reading those emails was surreal. They had been discussing my apps for weeks before the HR meeting. David had forwarded links to the apps to Patricia. Patricia had forwarded them to their general counsel. Their general counsel had written a memo analyzing whether they had a claim. The memo was cautious. It said the claim was weak but worth pursuing because employees rarely fight back. That line made me angrier than anything else in the lawsuit. They knew they did not have a strong case. They were doing it anyway because they thought I would not fight. They were wrong. The depositions started in March. Mine was first. I sat in a conference room at their lawyer's office, Jennifer on my left, a court reporter at the end of the table, and their attorney across from me. His name was Richard something, and he had the kind of voice that made everything sound like an accusation. He started with basic questions. My job title, my responsibilities, how long I had worked at Apex. Then he moved to the apps. When did I start building them? What technologies did I use? How much time did I spend on them? I answered every question carefully. Jennifer had prepped me for 3 hours the day before. Do not volunteer information. Answer only what is asked. If you do not remember something, say you do not remember. Do not guess. Richard pulled up a printout of one of my Git commits. This commit was made at 9:30 p.m. on a Tuesday. Is that correct? Yes. Were you working from home that day? I was home that evening, yes. Did you work from home during the day? No. I was in the office. So you went home after work and then worked on this app? Yes. And you are saying you did not use any knowledge or skills you learned at Apex to write this code? I used general software engineering knowledge, the same knowledge I had before I started at Apex and would have after I left. I did not use any proprietary information, any company code, or any specific techniques unique to Apex. He did not like that answer. I could tell by the way he paused, flipping through his notes like he was looking for a better angle. You used React for the front end of these apps, is that correct? Yes. And you use React at Apex? Yes. So you learned React while working at Apex. I learned React before I started at Apex. I have been using it for 6 years. He moved on. He asked about my work schedule, my performance reviews, whether I had ever worked on personal projects during work hours. I said no to that last one, and I meant it. I had been careful, obsessively careful. The deposition lasted 4 hours. By the end, my head hurt, and my throat was dry, and I wanted to throw something. But I had not slipped. I had not given them anything they could use. Jennifer and I walked out together. She waited until we were in the elevator before she spoke. You did well. It did not feel like it. He was fishing. He did not catch anything. Their depositions were next. David went first. I was not allowed to be in the room, but Jennifer told me about it afterward. He had been nervous, stumbling over answers, contradicting himself. He admitted he had no direct knowledge of when or where I built the apps. He admitted he had never seen me work on them during work hours. He admitted the apps did not compete with Apex's business. Patricia's deposition was worse for them. She admitted she had never reviewed the employment agreement language before the HR meeting. She admitted she had relied entirely on the general counsel's memo. And when Jennifer asked her if she knew of any other employees who had been asked to sign over their side projects, she hesitated just long enough to make it clear the answer was yes. Jennifer filed a motion to compel. She wanted the names of those other employees. She wanted their employment agreements. She wanted any communication about their side projects. Apex fought it. They said it was not relevant. Jennifer argued it showed a pattern of overreaching IP claims. The judge agreed with Jennifer. 2 weeks later, we got the documents. 5 other employees over the past 4 years. 3 had signed over their projects. 2 had quit instead. I read through the files, and my anger turned into something colder. This was not about my apps. This was about control. About a company that thought it owned every idea that passed through an employee's head. Jennifer reached out to the 2 who had quit. One did not want to get involved. The other, a guy named Marcus who had built a fitness app, agreed to talk. He had signed an NDA when he left, but Jennifer said the NDA did not cover testimony in litigation. Marcus's story was almost identical to mine. Casual conversation about a side project. HR meeting. Demand to sign over the IP. He had quit instead of fighting because he could not afford a lawyer. I asked Jennifer if he could be a witness. She said yes. We were building a case. Not just that I owned my apps, but that Apex had a pattern of making baseless IP claims to intimidate employees. In May, we got our first real victory. Apex had claimed in their complaint that I had used company time to work on the apps. Jennifer had subpoenaed my keycard logs, which showed every time I badged in and out of the office. She cross-referenced them with my Git commits. Not a single commit had been made while I was in the office. Not one. She filed a motion for partial summary judgment on that claim. The judge granted it. The claim that I had used company time was dismissed. It was a small victory, but it felt huge. One of their arguments was gone. And it had cost them credibility with the judge. Their lawyer called Jennifer the next day. He wanted to talk about settlement. Jennifer and I met at her office. She had printed out their settlement offer. They would drop the lawsuit if I agreed to stop distributing the apps and pay their legal fees. I laughed. It was not a happy laugh. They want me to pay them for suing me? They are posturing. They know they are losing. This is them trying to save face. What do we counter with? Jennifer leaned forward. We ask for everything. They drop the lawsuit. They pay our legal fees. They agree not to make IP claims against any current or former employees for side projects that do not relate to the business. And they revise their employment agreement to comply with California Labor Code. That last part surprised me. You think they will agree to that? No. But we start high. We negotiate down. And we make it clear that if they do not settle, we are going to trial. And we are going to win. And it is going to be public. She sent the counteroffer that afternoon. Their response came 3 days later. They rejected it. But the tone had changed. Less aggressive, more defensive. They were worried. Good. They should be. Discovery is where lawsuits get ugly. It is not dramatic. It is not like the courtroom scenes in movies. It is hundreds of pages of documents, emails with subject lines like quick question and following up, spreadsheets that make your eyes cross. But it is where you find the truth. Jennifer requested every document related to employee IP claims for the past 10 years. Apex pushed back, said it was overly broad, not relevant. The judge ordered them to produce it anyway. The documents arrived in June. 4,200 pages, delivered as PDFs on a thumb drive. Jennifer and I split them up. She took the legal memos and policy documents. I took the emails and employee files. I read for 3 days straight. My eyes burned. My back hurt from sitting in the same position. But I kept reading, because every page made me angrier and more certain that we were right. There were 12 employees over 10 years. 12 people who had mentioned side projects and been told they belonged to the company. 8 had signed over their work. 3 had quit. 1, me, had sued. The projects were all over the map. A recipe app, a workout tracker, a budgeting tool, a language learning app, a meditation app. None of them competed with Apex's business. None of them used company resources. But Apex had claimed them anyway. I found an email from 5 years ago, from the General Counsel to the CEO. Subject line, IP acquisition strategy. The email laid it out plainly. Employees often build valuable side projects. If we can claim ownership through the employment agreement, we can acquire IP at zero cost. Even if the legal basis is questionable, most employees will not fight. I read that email 3 times. Then I forwarded it to Jennifer with one word. Evidence. She called me 10 minutes later. This is it. This is the pattern. They have been doing this systematically. Can we use it? Absolutely. This goes beyond your case. This is a policy of intimidation and misappropriation. What does that mean for us? It means we are not just fighting for your apps anymore. We are fighting to stop them from doing this to anyone else. I sat with that for a moment. I had started this because I was angry about my own work, but now it was bigger. It was about Marcus, who had quit rather than fight. It was about the 8 people who had signed away their projects because they did not know they had a choice. Jennifer filed an amended cross-complaint. She added claims for unfair business practices and violation of California Labor Code Section 7833, which prohibits employers from requiring employees to assign inventions that do not relate to the company's business. And she asked for class certification. She wanted to represent all current and former Apex employees who had been forced to sign over side projects. Apex's response was immediate and panicked. They filed a motion to strike the class claims. They argued that each case was individual, that there was no common pattern, that class certification was inappropriate. The hearing was in July. I sat in the courtroom, in the back row, and watched Jennifer argue. She was calm, methodical, devastating. She walked the judge through the documents. The email about IP acquisition strategy, the 12 employees, the pattern of claims that had no legal basis. The judge asked Apex's lawyer one question. Do you dispute that your client has made IP claims against multiple employees for side projects unrelated to the company's business? The lawyer hesitated. We dispute the characterization that the claims had no legal basis. That is not what I asked. The lawyer tried again, talking about good faith interpretation of the employment agreement, about protecting company interests. The judge cut him off. I am going to grant class certification. We will set a schedule for class notice and opt-in. I watched Apex's lawyer sit down. He looked like he had been hit with something heavy. Jennifer came out of the courtroom and found me in the hallway. We won. What happens now? Now we notify every current and former employee. Anyone who was forced to sign over a side project can join the class, and Apex has to face all of them at once. The class notice went out in August. Jennifer drafted it, the court approved it, and Apex had to send it to every employee who had worked there in the past 10 years. The notice explained the lawsuit, the claims, and the right to opt in. Within 2 weeks, 37 people had joined. 37 employees with side projects they had been forced to sign over or abandon. The projects ranged from mobile apps to websites to open-source libraries. Some were still active. Some had been shut down years ago. But every single person had a story about being told their nights and weekends belonged to the company. I read some of their declarations. A woman who had built a childcare coordination app and been told to stop working on it or face termination. A man who had created an open-source data visualization library and been forced to transfer the copyright. A woman who had been building a platform to help freelancers find work and had quit rather than sign it over. Every story made me more certain we were doing the right thing. Apex tried one more time to settle. Their offer was better this time. They would drop the lawsuit against me, pay my legal fees, and agree not to enforce the IP clause against current employees for projects unrelated to the business. But they would not revise the employment agreement. They would not pay damages to the class members. And they would not admit wrongdoing. Jennifer and I talked it over. I could take the settlement. I could walk away with my apps, my legal fees covered, and call it a win. But the other 37 people would get nothing. The 8 people who had already signed over their projects would not get them back. And Apex would keep the same employment agreement, ready to use on the next employee who mentioned a side project. I told Jennifer, no, we go to trial. She smiled. I was hoping you would say that. The trial date was set for October. 4 months to prepare. 4 months to build the case that would not just win my apps back, but change how Apex treated every employee who walked through their door. 4 months to make sure that when I said see you in court, I meant it. The legal bills started piling up in September. I had burned through my retainer in the first 3 months. Now I was paying as we went, and the invoices came every 2 weeks like clockwork. $5,000, $7,000, $6,000. Each one a little piece of my savings account disappearing. I picked up freelance work to cover it. Nights and weekends, the same time I used to spend building my apps, now spent building websites and fixing bugs for clients I would never meet. The irony was not lost on me. My friends started asking questions. Was it worth it? Could I really afford this? Maybe I should just settle and move on. I understood where they were coming from. From the outside, it looked like I was throwing money into a fire for the principle of the thing. And maybe I was. But every time I thought about settling, I thought about that email. IP acquisition strategy. Employees will not fight. I was fighting, and I was not going to stop. But it was hard. Harder than I had expected. The lawsuit was always there, in the back of my mind, even when I was trying to focus on other things. I would wake up at 3 a.m. thinking about depositions, about trial strategy, about what would happen if we lost. Jennifer kept telling me we were going to win. The evidence was on our side. The law was on our side. But evidence and law did not always matter. I had been a software engineer long enough to know that sometimes the system just fails. In late September, Apex's legal team changed tactics. They filed a motion to exclude Marcus as a witness. They argued that his situation was different from mine, that his testimony was not relevant, that allowing it would be prejudicial. Jennifer fought it, but the judge granted the motion. Marcus was out. That hurt. Marcus's story was powerful. It showed the pattern, showed that I was not the only one. Without him, the case felt smaller, more isolated. Then their lawyer started playing games with the trial schedule. He filed a motion to continue the trial date, claiming he needed more time to prepare. Jennifer opposed it, but the judge granted a 2-month extension. The trial moved from October to December. 2 more months of legal bills. 2 more months of waiting. 2 more months of my life on hold. I called Jennifer after the hearing. Is this normal? Unfortunately, yes. They are trying to exhaust you. Make it so expensive and so drawn out that you give up. I am not giving up. I know. But I need to be honest with you. If this goes to trial and we lose, you could be on the hook for their legal fees. It is not likely, but it is possible. You need to understand the risk. I sat with that. I had been so focused on winning that I had not really thought about what losing would mean. Not just losing my apps, but owing them money. Tens of thousands of dollars. Maybe more. How likely is it that we lose? I think we have a strong case, but I cannot guarantee anything. Trials are unpredictable. I thought about it for 2 days. I ran the numbers. I looked at my bank account. I calculated how much more I could afford to spend before I would have to make a choice between the lawsuit and rent. And then I decided. I was going to see it through. Not because I was certain we would win, but because I could not live with myself if I gave up. I told Jennifer to keep going. October was brutal. I was working 12-hour days, splitting time between freelance work and trial prep. Jennifer needed me to review documents, prepare for testimony, help her understand the technical details of the apps. Every evening was another video call, another stack of papers, another round of questions. I stopped seeing friends. I stopped going to the gym. I stopped doing anything that was not work or lawsuit. My roommate asked if I was okay. I said yes, but I was not sure I believed it. The meal planning app was up to 1,500 users now. People kept sending me messages, thanking me, asking when I was going to add new features. I did not have the heart to tell them I might lose the app entirely. that a judge might decide it belonged to a company that had nothing to do with building it. In early November, Apex made one final settlement offer. They would drop the lawsuit, pay half my legal fees, and let me keep the apps. But I had to agree to a non-disparagement clause. I could not talk about the case. I could not talk about their IP policies. I could not warn other employees about what had happened to me. Jennifer sent me the offer with a note. "This is a real offer. You should seriously consider it." I read it 3 times. It was tempting. I could walk away. I could keep my apps. I could stop hemorrhaging money. I could get my life back. But the non-disparagement clause stuck in my throat. They wanted to pay me to be quiet, to let them keep doing this to other people, as long as I got mine. I thought about the 37 people in the class. I thought about the 8 who had already signed over their projects. I thought about the next employee who would build something on their own time and be told it belonged to the company. I called Jennifer. "No, we go to trial." There was a pause on the other end of the line. "Are you sure?" "I am sure." "Okay, then let us win this thing." The trial was 3 weeks away. 3 weeks to prepare. 3 weeks to get ready to stand in front of a judge and make the case that my work was mine. 3 weeks to prove that when a company tries to take what does not belong to them, sometimes the employee fights back, and sometimes the employee wins. The break came from a place I did not expect, a paralegal at Apex. Her name was Sophie, and she had been working there for 2 years. She was not part of the lawsuit. She was not even on our radar. But she had been watching the case unfold, reading the court filings, and she had found something. She reached out to Jennifer through a secure email. Said she had documents that might be relevant. Said she was willing to talk, but only if we could protect her identity. Jennifer and I met her at a coffee shop in the Mission. She was young, maybe 25, and she looked terrified. She kept glancing at the door like someone might walk in and recognize her. I could lose my job for this. Jennifer leaned forward. "What you share with us is protected. If they retaliate, that is a separate legal issue, and we will handle it." Sophie pulled out a folder. Inside were printed emails, internal communications between Apex's executives and their legal team. Communications that had not been turned over in discovery. They are supposed to produce these, right? In discovery? Yes. If they are relevant, they are supposed to produce them. I read the first email. It was from the CEO to the General Counsel, dated 2 months before my HR meeting. Subject line: monetizing employee side projects. The email was explicit. The CEO had seen my meal planning app. He thought it had commercial potential. He wanted to know if there was a way to claim ownership and either monetize it or sell it to a larger company. The General Counsel's response was cautious. The employment agreement language is broad, but California law limits what we can claim. If the employee fights, we might lose, but most employees do not fight. The CEO's reply: "Then let us make sure she does not want to fight. Have HR handle it quietly." I read it twice. Then I looked at Sophie. They knew. They knew the claim was weak, and they did it anyway. There is more. The next email was from 3 weeks later, after I had walked out of the HR meeting. The CEO to the General Counsel: "She is not backing down. What is our exposure?" The General Counsel's response was a full legal analysis. He laid out the risks. If she has good documentation, we will lose on the merits. If she finds out about the other employees, this could become a class action. Recommendation: settle quickly and quietly. But they had not settled. They had doubled down. They had filed a lawsuit, dragged it out, tried to exhaust me. Why? Sophie pointed to the last email in the stack. It was from the CEO to the board of directors. We are pursuing the IP claim against the employee to establish a precedent. Even if we lose this case, it sends a message to other employees that we will fight. The cost of litigation is worth it for the deterrent effect." Jennifer read that email and then looked at me. "This is it. This is the smoking gun. Can we use it? If it should have been produced in discovery and was not, we can file a motion for sanctions, and we can use it at trial to show bad faith." Sophie was shaking. "I could get fired. I could get sued." Jennifer put her hand on the table. "You did the right thing, and we will protect you. If they come after you, we will make it part of the case." Sophie left after 20 minutes. Jennifer and I stayed. We ordered more coffee and went through the emails again, making sure we understood every implication. "This changes everything." Jennifer nodded. "They did not just make a bad legal claim. They made it knowing it was bad as a strategy to intimidate employees. That is bad faith. That is sanctionable. What do? We file an emergency motion. We tell the judge these documents were not produced in discovery. We ask for sanctions, and we ask to admit them as evidence at trial." She filed the motion the next day. Apex's response was immediate and panicked. They claimed the emails were privileged. They claimed Sophie had stolen them. They claimed the motion was a stunt. The judge scheduled a hearing for the following week. I sat in the courtroom and watched Jennifer lay it out. The emails, the timeline, the fact that these documents should have been produced months ago. Apex's lawyer argued that the emails were attorney-client privileged, that they were protected work product. Jennifer countered that the crime-fraud exception applied. If the communications were in furtherance of a fraud or bad faith litigation strategy, privilege did not apply. The judge took a recess to review the emails. When he came back, his expression had changed. He looked angry. "I am going to allow these emails into evidence, and I am going to order sanctions against the plaintiff for discovery violations. We will determine the amount after trial." Apex's lawyer stood up. "Your Honor, we would like to request a continuance to reassess our position." The judge shook his head. "We are 3 days from trial. Your request is denied. See you Monday." Jennifer and I walked out of the courthouse into the December cold. The fog was rolling in off the bay, and the city smelled like salt water and exhaust. "We have them." I wanted to feel relieved, but all I felt was tired. Tired of fighting. Tired of spending every waking moment on this case. Tired of watching my bank account drain. But we were close. 3 days until trial. 3 days until I would stand in front of a judge and tell my story. 3 days until I would find out if fighting back had been worth it. That night, I got an email from Apex's lawyer. They wanted to talk settlement. Again. I did not even open it. I forwarded it to Jennifer with 2 words. No deal. We were going to trial, and we were going to win. The trial lasted 3 days. 3 days of testimony, evidence, legal arguments. 3 days of sitting in a courtroom watching Jennifer dismantle Apex's case, piece by piece. She started with the employment agreement. She walked the judge through the language, through California Labor Code, through the cases that made it clear that employers could not claim ownership of inventions unrelated to their business. Then she presented my evidence. The JIT logs with timestamps, the receipts for my laptop, the router logs showing every commit came from my home IP address, the keycard logs proving I was never in the office when I was coding. Apex's lawyer tried to argue that I had used company knowledge. Jennifer asked him to define company knowledge. He could not. She asked him to identify a single line of code that was proprietary to Apex. He could not. Then she brought out the emails. The ones Sophie had provided. The CEO's email about monetizing my app. the general counsel's warning that the claim was weak, the CEO's response that they were pursuing it as a deterrent. The judge read them in silence. Then he looked at Apex's lawyer. "You filed this lawsuit knowing you did not have a strong legal basis?" The lawyer tried to recover. "We believed we had a good faith argument under the employment agreement." The judge cut him off. "This email says you were pursuing the claim to establish a precedent and deter other employees. That is not a good faith legal argument. That is a litigation strategy designed to intimidate." The lawyer sat down. He did not have a response. Jennifer called me to testify on the second day. I walked to the stand, put my hand on the Bible, and swore to tell the truth. She asked me about the apps, why I built them, what they meant to me, how I had been careful to keep them separate from my work. I told the truth. I built them because I wanted to solve problems, because I wanted to create something that mattered, because my day job was fine, but it did not let me build the things I cared about. Apex's lawyer cross-examined me. He tried to make it sound like I had been planning to leave the company and compete with them. I said no. He tried to suggest I had used company time. I said no, and pointed to the evidence that proved it. He did not have much to work with. The evidence was too clear. On the third day, Jennifer called one of the class members to testify. A woman named Priya, who had built a childcare coordination app and been forced to shut it down. She talked about the HR meeting, the pressure, the fear of losing her job. She talked about signing the agreement because she had a mortgage and 2 kids and could not afford to fight. The judge listened, and I could see, in his expression, that he understood. This was not just about me. This was about a pattern, a system designed to take advantage of employees who did not know their rights. Closing arguments were on the afternoon of the third day. Jennifer stood up and laid it out. The law was clear. The evidence was clear. Apex had no claim to my apps, and they had pursued the lawsuit in bad faith, knowing they would likely lose, as a strategy to intimidate employees. She asked the judge to rule in our favor, to declare that I owned the apps, to award damages to the class members, and to sanction Apex for their discovery violations and bad faith litigation. Apex's lawyer gave his closing. He tried to argue that the employment agreement was ambiguous, that they had a reasonable interpretation. But his heart was not in it. He knew they had lost. The judge said he would issue a ruling within 2 weeks. Jennifer and I walked out of the courthouse. It was late afternoon, and the sun was breaking through the fog for the first time in days. The light was golden, slanting across the buildings, making everything look softer than it was. "How do you feel?" "Exhausted." She smiled. "You did well. You told your story. Now we wait." The ruling came 9 days later. I was at home, working on a freelance project, when Jennifer called. "We won." I sat down. "What?" "We won. Everything. The judge ruled that you own the apps. He ruled that Apex's employment agreement violates California Labor Code. He awarded damages to the class members. And he sanctioned Apex $50,000 for discovery violations and bad faith litigation. I could not speak. I just sat there, holding the phone, trying to process what she was saying. "Ella, we won." I started crying, not sad crying, relief crying. The kind of crying that happens when you have been holding something in for so long that when it finally releases, you do not know what to do with the space it leaves behind. The ruling was 32 pages. I read it that night, every word. The judge had not just ruled in our favor. He had eviscerated Apex's arguments. He called their litigation strategy troubling. He said their employment agreement was overbroad and unenforceable. He said their treatment of employees who built side projects was a violation of California public policy. And then, he did something I did not expect. He ordered Apex to revise their employment agreement and submit it to the court for approval. He ordered them to notify all current and former employees of the ruling. He ordered them to return the IP rights to every class member who had been forced to sign over their projects. 8 people got their work back. 8 people who had thought it was gone forever. The story did not end there. The ruling was public. It got picked up by tech blogs, then by larger news outlets. Apex's reputation took a hit. 3 of their investors pulled out. Their CEO resigned 2 months later. Other companies started revising their employment agreements. Law firms started advising clients to comply with California Labor Code. Employees started pushing back when they were told their side projects belonged to their employers. I did not set out to change anything. I just wanted to keep what was mine. But sometimes, when you fight back, you do not just win for yourself. You win for everyone who comes after you. My apps are still running. The meal planning app has 5,000 users now. The finance tracker has 3,000. I still do not monetize them. They are still just out there, free, helping people. But now, they are mine. Legally, definitively, mine. And no company can ever take them away. If this story resonated with you, if you have ever felt like someone was trying to take credit for your work or claim something that belonged to you, leave a comment. Tell me your story. Hit that like button. Subscribe, because I share stories about standing up, fighting back, and winning when the odds are stacked against you. Share this with someone who needs to hear that sometimes, when you say, "See you in court," you actually win. Because that is what happened to me. I said, "See you in court," and it was the beginning of their end.